Questions are sometimes asked around the provisions in place to move from one trustee to another, given the perpetual nature of charitable trusts. Once a charitable trust has been established, its trustee operates and administers in accordance with its governing instrument, a trust deed or a will, and within the principles of the laws of trusts. The trustee is the legal owner of the trust assets. It is the trustee that has the legal responsibility in law to protect these assets, to invest them and administer them according to the terms of the deed. At the time of setting up the trust, the settlor has the option to include a substitution trustee clause in the deed, a power which is usually conferred on an individual or co-trustees, and it can be activated under certain circumstances. Unless such a term is specifically written into the deed or will by the settlor, the default portability mechanism is a state-based court process. Of course, stakeholders dissatisfied with any aspect of a trustee's performance should always make their issues known directly to the trustee. As a licensed trustee, the trust company has a compliance system in place to record and manage any issues or complaints and inform its board and management of the progress of these issues as appropriate. There's been some discussion around whether the portability rules of charitable trusts, and particularly testamentary charitable trusts, should be relaxed. The trust company opposes portability as an action exercisable outside the court process by a co-trustee or another interested party for a couple of important reasons. It would be contrary to the wishes of the person who created the trust, and it also has the capacity to serve interests not aligned to the settlor's or testator's intentions. While we support the new federal regulator for charitable trusts, the Australian Charities and Not-for-Profit Commission, or ACNC as it is known, we would like to note our concern that the ACNC has been given certain powers to remove directors of trustee companies which may have the effect of extending the portability provisions of trusts other than ancillary funds, where the newly legislated guidelines have made appropriate provisions. We are mindful of our significant privilege and responsibility as trustee and administrator of over 450 charitable trusts in Australia. We are proud of our track record and reputation in executing our role as trustee for this diverse portfolio, with diverse requirements. Ultimately, we remain guided by the individual trust deeds or the will, and interpreting the wishes of our benefactors. Due to the broader investment in our philanthropy business over the last few years, such as investing in our scholarships and awards portfolio and initiating a new engaged philanthropy grant-making model, we are confident of delivering a holistic service to all our philanthropic clients, be they individuals or corporations. Please talk to us about any questions you have regarding portability for charitable foundations and how the trust company can help you structure and promote your philanthropy.